it's been a lot of drama in the employment,
Yeah.
environment.
Sure.
What's the difference between termination and dismissal?
Now, when we talk of termination, basically, what we're trying to say is termination is a way of bringing a contract of employment to an end. But we need to understand one thing. There are several types of termination. We have termination by notice, we have termination by breach, we have termination by performance, we have termination by agreement, and most importantly, we have termination by dismissal. So we need to understand one thing. Dismissal is one of the ways of termination.
Yes,
But again, apart from dismissal, there are several other ways of termination. So dismissal is infused as one of the ways of termination. But most importantly, we need to understand the fact that ordinary termination of an employment does not suggest a wrongdoing. But dismissal in itself suggests a wrongdoing. So dismissal is usually as a result of gross misconduct.
yes, please.
Now, in the case of Boston Deep Sea Fishing and Ice Company against Ansel, gross misconduct is defined as any conduct that is grave and weight in character as to cast aspersion on the relationship of confidence that exists or to exist between an employer and the employee. So when you're talking of dismissal, dismissal is the punitive type of termination. Dismissal is termination as a result of punitive conduct on the part of the employee. And dismissal carries with it, an implication that the employer has actually committed a wrongdoing to an extent that the employer no longer wants to proceed, in the contract of employment with the employee. But termination is different. If a contract of employment is ordinarily terminated, that can be by agreement, that can be by performance, that can be by notice as contained in the contract of employment. But when we're talking of dismissal, we're talking of an existential wrong that the employee has performed, upon which the employer now decides to terminate the contract of employment. So there are consequences that comes with this. Now, when an employer dismisses, the implication is the employee, the termination takes immediate effect without recourse to what is contained in the contract of employment. So if an employer dismisses now, the dismissal takes immediate effect, and the employee cannot claim that the employer did not give him or a 1 month notice or 1 month salary in lieu of notice. But when it comes to termination, what we're saying is that either of the parties, they have the right, they are terminating the contract of employment. So even one difference that exists between termination and dismissal is that either the employer or the employee can terminate, but it is only the employer that can dismiss. So dismissal is the right that accrues to the employer because the employer has committed a misconduct. But when it comes to termination, is a right that accrues to either the employer and the employee. Now, for an employee can terminate by giving notice. An employer can also terminate by giving notice. So that's just the difference.
Is it safe to have those kind of misconduct captured somewhere, maybe on terms of agreements, so that the employee will understand that, okay, should you do this, this is actually the appropriate sanction for you? Because I've seen instances where the employer terminates or dismisses the employee, and few months down the line, the employee comes with, or the former employee now brings a lawyer to fight the organization for wrongful dismissal, because I think that is actually the bone of contention.
Okay, now, before I even go ahead to address the issue of wrongful dismissal, we need to first address something. Like I said before, dismissal is a right that inures to an employer. So an employer can dismiss whether that right is expressly stated in the contract of employment or not. We need to understand that very clearly. Now, but one thing we also now need to understand is that whether or not the employer can dismiss, that condition, that behavior of an employee need not be contained in any way. For example, there are acts that are generally considered as gross misconduct. For example, maybe stealing, maybe fighting. So if the act is perpetrated or committed by the employer can go ahead to dismiss, save that the employer also follows the appropriate procedures. Because there are appropriate procedures that are attached to dismissal. And if the employer does not follow that, then that is when wrongful dismissal that you mentioned can come in. But it is not the position of the law that the conditions or the conduct, the dismissible conduct upon which the employee will be dismissed needs to be expressly stated in the employee handbook or contract of employment. Although it makes it very easy if it is contained in the employee handbook or contract of employment. I would suggest or I will advise that it is contained. But if it is not contained therein, it doesn't mean that the employer cannot dismiss. And I'll give you this example. Assuming drinking of alcohol is the employer considers this as a dismissible offense, but it is not contained in the employee handbook where the list of dismissible offenses are considered, does it mean that the employer cannot dismiss as a result of the employee being consistently engaging in drinking alcohol? Of course, the employer can do that, but there are some conditions in which the employer will follow, upon which it will now be clear, that the employer intends to dismiss. And if the employer fails to follow this condition, that is when we can now say that, okay, a claim of wrongful dismissal can arise or be justifiable.
Okay, so before we quickly take a